Ladies and gentlemen, prepare yourself to be transported to the future is now with our next group of speakers. First up is Hubert Allen. Mr. Allen is the Executive Vice President, General Counsel, and Secretary of Abbott Laboratories. Sharing with us his perspective on the litigation landscape, please join me in welcoming Mr. Hubert Allen.
Thank you very much. Thank you for having me here today. I didn't realize we were going all the way to the future, but I guess we'll try to get there at least part way. I wanted to spend my time with you today just highlighting an issue that is facing companies like ours that sell food and nutritional products in the United States. And it's an issue of the changing nature of the class action landscape. Historically, food companies have always faced class action lawsuits. We face class action lawsuits on label claims that generally broke down into two common sense ideas. One idea was that the label was somehow false because it suggested the product was something that it was not. And the other is that the claims made by the company in the advertising or on the label itself promoted benefits that were somehow exaggerated or somehow false. And that has been the landscape for a very long time. There are many cases that highlight this. In one case, a blueberry waffle company, for instance, was sued in a class action lawsuit because it was alleged that their waffles did not actually contain blueberries. In another, a carrot cake mix company was sued because it was alleged that their carrot cake mix did not actually contain carrots. And that was pretty understandable. In another case, a green tea company was sued because they had things on their label like the green tea burned calories. And they were essentially making claims that if you drank their product, it would help you lose weight. But the number of food class actions is on the rise. In the ILR's report on the lawsuit ecosystem in 2013, the researchers in that report note that in 2008, there were only 19 federal class action lawsuits regarding food. By 2012, that number had grown to 102. And the number grew in part because there's been a shift in the way in which plaintiffs' law firms have brought these types of suits. Gone are the common sense notions of consumer deception, and now what companies face are lawsuits that are basically surrounding issues of regulatory interpretation. Perhaps the best example of this are the natural cases. The natural cases stem from the fact that the FDA has never actually defined what natural means. Many foods carry the label natural, and many of you have seen them if you're in a grocery store, but the FDA has never actually defined what natural means. In 1991, they made an attempt at putting in place an informal policy which was aimed at defining natural, but never actually made it into regulation. Now, the policy itself claimed that a natural food would be a food that did not contain artificial or synthetic ingredients that were not expected to be in food. That was their draft policy. They put it out for comments. Comments may or may not have come, we don't know, and they never actually made it into a regulation. What began after that shortly was that companies started getting sued as to whether or not their products were natural and whether the term natural was deceiving. Now, for the plaintiffs' law firms, this was a great thing, right? Because suddenly they could bring lawsuits against a wide number of people. No longer did you have to scrounge around and figure out if somebody had blueberry waffles that did not actually have blueberries in them. You could bring lawsuits against any company that had a food that was labeled as natural, which of course would be many companies. And secondly, you got to bring a lawsuit where you got to define the standard because the government had failed to do so. And so it began. In the early days, judges looked at these lawsuits and decided in part that the FDA actually was the one who should decide, that regulators should decide what natural was rather than courts and rather than juries. The FDA declined to do that. In one suit in particular, they were asked explicitly to define it, and they simply declined to do that. And so the suits started to grow, and they grew exponentially. You had suits that claimed that a tea product was not natural because it had high fructose corn syrup, even though it is made from corn. You had cases around fruit smoothies and whether or not synthetic vitamin C was a problem because it was synthetic. We ourselves had a case on our nutritional bars, and the case centered around whether or not ingredients in our products, which are determined to be synthetic under the USDA's organic regulations, were in fact natural, even though the product wasn't labeled as organic. We won that case. We won that case by sticking with it. We won that case by eventually getting to a point where the class was not certified, but we did so, obviously, after taking a lot of time and also after expending a lot of money. I'll point out again for the defense lawyers, a lot of money. But we won it. But it shouldn't be this way. And so I come here to raise the issue. I come here to point it out. I come here to note that the trend is rising. It is going beyond mere issues of sort of what the product says. It's going into issues of how you test products. It's going into issues of whether or not one ingredient or the other is permissible. And they're all being decided through these class action lawsuits, which is not the best forum. I think the solution ultimately is greater regulation. Regulation which is clear, regulation which is national, and regulation which preempts courts from getting into the business of regulation. But one last thing I'll mention, just in case I haven't convinced you that things are getting slightly off the rails in the food business. As we sit here today, the USDA is contemplating changing regulations on infant formulas that label themselves as organic. We have an infant formula, Similac Organic, that labels itself as organic. And they're considering whether some ingredients in that formula or in any formula should be included or excluded in order to have an organic label. We're being sued today by a plaintiff who is claiming that our current formula, although it has been certified by a third party, although it meets all of the regulations that are in place today, that formula deceives consumers. Not because of something that is in the law today, but it deceives consumers because it does not anticipate and it does not follow the future regulations that the USDA might point out. You might think a judge would kick that out, that it is hard to have a lawsuit based on future potential regulations, but the judge in this case has not seen fit to do that. So my message is simple. Food litigation is rising. Food litigation is expensive. Food litigation is problematic and is a terrible way of regulating an industry. What we need are for courts to back away from the ridiculous idea that a company can be sued for something that might happen in the future, to back away from the ridiculous idea that they are the best judges of what should be in products, what should be in food, and that they are smart enough, technically based enough, and complete enough to actually regulate complicated issues of food construction. Thank you.
Our next speaker, ladies and gentlemen, is Howard Schrader, Executive Vice President and General Counsel for ACE Overseas General. Please welcome Howard Schrader.
Thank you. Thank you very much. Thank you on behalf of ACE Insurance. I have two objectives today. The first, I think, is to disabuse you of the idea of using the words insurance lawyer and hot topics in the same sentence is an oxymoron. The second is to try to take an incredibly complex litigation that's gone on for almost a quarter century and compress it into the 9 or so minutes I have in this TED Talk today. I'm going to expand on what we talked about this morning on the subject of third-party litigation funding. We talked about it in the abstract. I'd like to describe how it works for you in the real world. We talked about how it's governed in relatively well-established jurisdictions like England, Australia, the United States, Canada. I'd like to talk about how it works in much more unusual jurisdictions and litigation venues when you cross borders a little bit. And I'd like to talk about what happens to companies like mine, and perhaps someday yours, when you encounter the reality of litigation funding. To do that, I'm going to do what litigators love to do, which is, of course, to tell a war story. In my case, it literally is a war story. We're talking about the Liberian Civil War, to be exact, one of the most destructive conflicts in the history of modern Africa that lasted more than a decade and took the lives of tens of thousands of innocent people and destroyed an entire country for well more than a decade. What does that have to do with an insurance company or third-party litigation funding? Well, to take a very complex series of corporate transactions and oversimplify it, my insurance company bought the assets and unfortunately became responsible for the liabilities of another insurance company, which many years before had sold property insurance in West Africa, including in Liberia, well before the Civil War started. Some Liberian businessmen whose properties were completely destroyed during the war wanted to collect on their property insurance. But the insurance policy, like most property and fire insurance policies, had a very standard clause that said that coverage was excluded in the event of a war or a civil insurrection, not surprisingly. The businessmen did what I've learned as an insurance lawyer, policyholders sometimes do. They decided to sue their insurance company. They didn't do so in Monrovia, Liberia, because by then the country had been reduced to a near Hobbesian state of nature. So instead, they went to the United States and found a federal court in Philadelphia where they were entitled to sue, had an American-style lawsuit, American-style discovery, an American-style trial, but they also had an American-style federal judge who knew how to read a contract, realized that the war exclusion applied, and rendered judgment for the insurance company. We thought that was the end of it. That was 1995. The plaintiffs then went back to Liberia, where they were able to find a courthouse standing and a judge standing, and they filed the exact same lawsuit over the exact same policy against the exact same defendants, and this time obtained, or procured, maybe the better word, from a Liberian judge, a $60 million judgment against the insurance company. The lawyers in the room can probably guess what happened next. Back in Philadelphia, across on the other side of the Atlantic, the American judge issued an injunction barring anyone, including these plaintiffs, but anyone, from interfering or trying to negate the American injunction that had been handed down, or from trying to enforce the bogus Liberian $60 million judgment that had been issued. That was around the year 2000. We thought the case was over, but that's where litigation funding entered the picture. The Liberians found new lawyers in, of all places, the British Virgin Islands, on the island of Nevis, and also in Switzerland. And they found a funder, not one of the big funding outfits you've heard about, but an Irish businessman who decided to take a flyer and put some money down on a litigation that promised a huge return in the event that the Liberian judgment was eventually upheld somewhere. And, interestingly enough, they found a compliant Liberian insurance regulator who was happy to have himself declared as the receiver of the insurance company, but not before he had asked to have a special commission paid to him of 1% of any possible recovery. An unusual position for a regulator to take, even the rogue regulators we were talking about before. Armed with that, the funders and the lawyer entrepreneurs and the plaintiffs, at least the nominal plaintiffs, sued us in, of all places, the Cayman Islands. And their argument is familiar to anyone who remembers anything about the recent Chevron case. Their argument was, Your Honor, we have a judgment from a sovereign court. Under principles of international law and comedy, you're not supposed to look too much under the hood. You should simply honor this judgment, not ask too many questions about it, and help us enforce it against the big insurance company. I think they were looking not so much for a huge judgment, so much as for a quick settlement against a company that would be desperate to get out of a badly leveraged position. What they didn't count on was that we would go back to Philadelphia this time, to the federal judge, and ask for an order of contempt for violation of that original injunction, and not just against the nominal plaintiffs, but also against the Liberian receiver, and not just against the Liberian receiver, but against the lawyers who had organized this violation of the injunction, and not just against the lawyers, but also against the litigation funders themselves, to have them all held in contempt. But to do that, we had to find out the identity of the litigation funders, because as usual, they tried to make themselves anonymous. That was 2008. It took us until 2014, after years and years of litigation and appeals and violations of discovery orders, before we were able to discover the trail of who had actually funded the case, where the money went, and serve all of them in Ireland and other places with petitions to have them held in contempt, a petition for which we are still awaiting a decision from the court. Now, what have we at our company learned about the litigation funding business from our decades-long experience in this? A couple of things that I think will be of use to you as you encounter this phenomenon. One, there isn't a lot of transparency there. They do their very best to keep themselves anonymous, unless it's in their interest to boast about a big litigation win. If sunshine is supposedly the best disinfectant, there's not a lot of sunshine in the litigation funding business, at least in our experience. Second, the lawyers and the funders seem to have little compunction about throwing their plaintiffs under the bus if it suits their purposes. The funders present themselves often as having interests that are perfectly aligned with those of the plaintiffs. In our case, they ended up abandoning the case in the Cayman Islands when it became clear that we would ask for security for costs greater than their business model called for, and more importantly, that we would ask for identity of the people behind it. At that point, they decided to chuck their investment and chuck the plaintiffs. The third thing we discovered is that the picture of litigation funding that you see from the large litigation funding companies is not really the reality of what happens outside of those big companies and outside of the established jurisdictions. If you read some about these companies or look onto their websites, you get a very wing-tipped, leather-bound picture of conservative stewards of their investors' assets who are always consulting law professors who they hire for ethical advice, who have stringent codes of conduct, always voluntary, never compulsory, that they follow, and whose interests are perfectly aligned not only with those of the plaintiffs, the investors, but the justice system as a whole. What we found was very different. It wasn't really like Goldman Sachs. It was more like Wolf of Wall Street. It's a wild west out there, especially when you leave the established jurisdictions, and I think it's going to get wilder as the years proceed in the absence of any modicum of minimal regulation of how these outfits work. If you want some indication of where it might be going, you might have read in the Financial Times a few months ago about a website called Crowdfunding Justice for You, which bills itself as the world's very first crowdfunding third-party litigation website. I wonder where it's going to go next. One could possibly, sometime in the near, not too distant future, see a Tinder for litigation funding. Perhaps if you see a particularly hot tort case, you can swipe left and meet a particularly attractive plaintiff. We haven't quite gotten there yet, but I think in the absence of some kind of effective regulation of litigation funding, we're going to have a very wild and uncontrolled atmosphere for plaintiffs, as well as defendants, and most of all, for the justice system that we depend upon. Thank you very much.
Ladies and gentlemen, our final speaker in the Future Is Now series is Ms. Kimberly Phillips. Ms. Phillips is the Global Litigation Associate General Counsel for the Americas at Shell Oil Company. Ladies and gentlemen, please welcome Kimberly Phillips.
So I found this cartoon both funny and sad, kind of all at the same time, right? I know many of you in the audience can relate to it. It does shed light on a mindset that I want to talk to you about today. I want to start by asking you a couple of questions. One, what has happened to our civil justice system? And two, more importantly, what do we need to do to improve our system for our businesses, for our communities, and future generations? I want to start by taking a walk back in time. I don't know if any of you recognize this lady. She played an important role in the development of an important civil justice concept, and that is the right to be compensated for harm done by a corporate entity. This lady is Mary Donahue. Back in 1928, she went into a cafe in Scotland. She ordered a ginger beer. She drank about half of it, only to discover that there was a decomposed snail in it. Understandably unhappy, she filed a lawsuit. And from that lawsuit emerged an important principle: the obligation of a manufacturer to take reasonable care to protect consumers. Now, I get it, in our lawsuits today, reasonable care can be tricky and frankly quite elusive, but the principle is nevertheless sound. This young girl, not sure if any of you recognize her, but she too played an important role in a key civil justice concept, and that is the right of a group of people to band together and seek justice through class action litigation. Really, her story means a lot to me on a personal level. So for as long as I can remember, I have always wanted to be a lawyer. 9, 10 years old. My cousin Angie, she always wanted to play house. I always wanted to play lawyer. She didn't think a lawyer was a real game, but I didn't think house was a real game. You see, I had learned about lawyers and our civil justice system and all the good that it had accomplished during the civil rights era. So Thurgood Marshall quickly became one of my heroes. This young girl is Linda Brown, the student at the center of the class action litigation, Brown versus the Board of Education, that resulted in a profound and important change in our society. See, I'm not here today because I want to upset the rule of law or upset civil justice. On the contrary, I believe very much in our system, and I believe in the rule of law. You see, our system has done many great things: level playing fields, protected vulnerable people, and corrected and prevented corporate misbehavior. I don't know, there are a few Texans in here. I saw you earlier today. You probably recognize this man. His name is Wallace Jefferson. I heard somebody whisper it. He's the first African American to serve on the Texas Supreme Court, and he later became the Chief Justice of that court. I saw him a couple of months ago. He was speaking on a topic completely unrelated to civil justice, but he said something very simple and profound. The courts exist to serve the people. Of course they do. We can all agree on that. I think the problem that we're having today in our system is the courts aren't serving the people. They're serving some of the people, but not serving the people. Why do I say that? The playing field in our legal system has become uneven. It's imbalanced. There's a bias in it. It's an open secret that there are many states, many counties that are very plaintiff-friendly. We have lots of plaintiff-friendly judges. This problem is exacerbated when we have a system that allows cash contributions toward judicial elections, and then those contributions skew the outcome of those elections. That bias, that uneven playing field, has a real-world impact. So, I lead a team of about 60 people: lawyers, paralegals, support staff. We are responsible for managing Shell's litigation risk throughout the entire Americas region: South America, the Caribbean, Canada, and of course here in the United States. Every day we make decisions about our cases. Do we settle them? If so, for how much? When? Do we take a case to trial? What are the consequences of that? So, most times, our decisions obviously are based on the facts, based on the law. But all too often, our decisions are impacted by whether the case is in one of these plaintiff-friendly jurisdictions. I'll give you a perfect example. A couple of months ago, a team comes to me. They propose a 7-figure settlement for a case, or risking going to trial in a very plaintiff-friendly jurisdiction where punitive damages might be available. Well, I thought this was easy, right? The facts were on our side, science, causation, all in our favor. The plaintiff's lost wages claim, quite frankly, was laughable. Well, and the plaintiff himself, let's just say he was not a Boy Scout. But with all of that in our favor, I couldn't be sure we would secure a defense verdict, or that any plaintiff's verdict wouldn't involve punitive damages or would be less than the amount of the settlement on the table. We fussed and got the number down, but reluctantly I agreed to settle. And I say reluctantly because we, whether it's me in my individual capacity or me in my representative capacity for Shell, we have a right to expect a level and fair playing field no matter what state or county we are in this country, and that's not happening. You know, Towers and Watson did a study and concluded that $265 billion had been spent on court costs, lawyers, and judgments by U.S. companies and medical practitioners in the year 2010 alone. How much of that money could have been used to build a new manufacturing plant, to make research and development opportunities available, or to invest in other job-generating initiatives? So what do we do about it? Well, thanks to ILR, they've identified 101 ways to improve our state legal systems. They've also issued some best practices around judicial selection. So what if we stop electing judges? particularly in partisan races. The law is nonpartisan, ladies and gentlemen. Shouldn't our judges be as well? Shouldn't a judge be able to make a decision based on the facts and the rule of law without fearing some punishing re-election down the line or losing some important campaign contributor? What about giving jurors real information about a plaintiff's actual losses and putting some reasonable parameters around non-economic and punitive damages? My personal favorite, venue, forum shopping. We all know it's happening. We all know it's pervasive. What exactly is wrong with enforcing the venue rules that we have, requiring a plaintiff to file a lawsuit where they live, where the defendant's principal place of business is, or where the cause of action occurred? And what if all the class action abuse we've heard about today could be curbed simply by linking the attorney's fees awarded to the value of the benefit received by the class or to the amount of work that the lawyer actually did in supporting the class? These are just some ideas. It is going to take a concerted effort from all of us to make these changes. When I say us, I'm talking about judges and lawyers. See, the lawyers, we kind of got ourselves into this mess, and it's going to be up to us to get ourselves out of it. My law school, the Thurgood Marshall School of Law at Texas Southern University, has a very simple motto around social progress: protect it, improve it, and pass it on. It is applicable here too. It is going to be up to us to protect everything that is good and right about our civil justice system, to work out the abuses, to eradicate them from our system, and to leave a system that is fair, credible, and free from bias for our future generations. I trust that you will leave here today more committed than ever to do just that. And I thank you for allowing me to be part of your afternoon. Thank you.